So we need to take that time to really understand the contents and all what it takes to make it. So let's keep pushing. We should be able to adjust. I once again make it clear that this is the last week for land transactions. From all where we started from, finally it has come to an end. So this is a week of basically two topics. Topic one is what we call expropriated property. Then topic two is what we call utilization of restricted stroke gazetted areas of land. That is to say, forestry, riverbanks, lake shores, swamps, etc. We want to see how we obtain licenses to utilize such places, then the necessary procedure, the necessary fees. We shall examine the law regarding authorization, which entities, what activities can be licensed and what activities cannot be licensed. What is the effect of carrying out environmental impact assessment? Is it relevant or it is not? So that's basically the workshop two. Then for workshop one, we are going to deal with expropriated property as we earlier on did it. Under this, we shall first ask ourselves what amounts to expropriated property? What is the procedure of dealing with expropriated property? Then, which entities do manage expropriated property? How is expropriated property managed and dealt with? How do we access expropriated property? That is to say, purchase, sell, or any other way. Then we shall look at the different remedies available to the parties that have been occupying such land. Also, our emphasis shall be basically on what happened, the different series of activities, the different laws that were enacted for purposes of protecting the interest of departed Asians. That will be basically our base of discussion in workshop one. Hope we are all prepared for this general recap of workshop one. Are we good to go, comrades? Yes?
Yes, Council, we are ready to proceed.
Okay. So, to make things a little bit simpler, as we did it last time, we were able to raise a couple of questions that we termed as guiding principles in appreciating the transaction of dealing with expropriated properties. We said that when you are dealing with expropriated property, first things first, what is expropriated property? What is expropriated property? When you look at, for you to be able to understand, we have basically three acts. The first act is known as the assets of departed Asians. That act operated before the property was expropriated. So if you want to understand what amounts to expropriated property, the process of expropriating property is under the Assets of Departed Asians Act. Then what amounts to expropriated property is under the definition section of Expropriated Properties Act. So this implies that the Expropriated Properties Act applies after the property has been expropriated. But before expropriation, we shall refer to the Assets of Departed Asians Act. Are we together?
Yes, Council.
Okay. So first, let's look at the process of expropriating property. When you look at Section 1 of the Assets of Departed Asians Act, it is very emphatic. It makes it mandatory that every departing Asian shall declare his or her assets or business, whatever the case may be. Then when you go to Section 2, Section 2 mandates the minister to maintain a register of declared properties. And after maintaining the register under the same section, a departing Asian should be granted a receipt as proof of declaration of his or her property. Then Section 3 establishes, Section 3 deals with what we call vesting of property in the government of Uganda. Vesting of the property in the government of Uganda. Then Section 4 establishes what we call the Expropriated Property Custodian Board, which has the sole mandate of managing expropriated property. So this implies that the process of expropriating property starts with 1, declaration of property under Section 1, then 2, maintaining a register of declared properties, then 3, issuance of the receipt as proof of declaration, then 5, vesting of the properties under the government of Uganda. So after vesting the property in the government of Uganda as per Section 4 and 3, because the custodian board was acting as an entity established by the government of Uganda. So after the property was vested in Section 3, the property became expropriated. But when you look at that act, the Assets of Departed Asians Act, it does not describe how to deal with that property specifically. So once the property has been vested in the government, that's where the process of expropriation ends. So where property is vested in the government, either by way of declaration or through other means that the government could afford, then that property is expropriated. Any question on what amounts to expropriated property? Yes? Yes, members.
No.
Any question? Yeah. Yes?
No question.
Okay. So now, after this property has been expropriated, then ask yourself, our second guiding question will be, which entity manages and controls expropriated property? Which entity manages and controls expropriated property? Okay. Remember now, the property we are dealing with is expropriated. We are no longer collecting assets of departed Asians. we have already collected and expropriated this property. So this implies that now we are crossing from what we call the Assets of Departed Asians Act to Expropriated Properties Act. So now we want to know which entity seriously deals with the expropriated property. Are we together? Okay. Yes. So when we look at section 2, subsection 1 of the Expropriated Properties Act, it is very emphatic and very clear that one, okay, that it uses the word revesting of properties in the hands of the government. Revesting, okay? Revesting, that means this property had already been vested in the government, but we are doing it the second time. Okay? We are doing it the second time. Why? When you look at the Assets of Departed Asians Act, it is an act which commenced on it commenced in the year of 1973, and this act just gathered property. It just did what we call gathering of property, but it never explained to people on how they should utilize this property. It's like giving your son or your daughter money and you don't give them instructions. They will use that money the way they deem fit. Okay? The way they deem fit. So by the time you realize that I made a mistake of giving my son money without instructions, by the time you ask your son that where is the money, your son may not be able to give you accountability. So it's the same thing that happened in expropriated property. After the Assets of Departed Asians Act collecting all the properties and putting them together, it never gave directions on how. So in 1983, after realizing the errors that were in the first act, the government, the governing government by then, revested the properties in the government under section 2, subsection 1. Then after revesting the properties in the hands of the government realized that a lot of people had dealt with, they had transacted on this property without authority, because the first act never clearly told people how to deal with the property. It just vested. So the custodian board is just a custodian, but this custodian had misappropriated the property by selling, leasing, whatever the case may be. So under section 2, subsection 2, paragraph A, the government said no, notwithstanding any provision conferring title, all transactions were cancelled. Which transactions? Transactions between 1973 and 1983. So between that period, these transactions were cancelled. So that means whoever bought, leased, acquired any land that was belonging to a departed Asian under the management of custodian board, the transaction was null and void. by virtue of section 2, subsection 2, paragraph A. And mark this, subsection 2, paragraph A only operates on leases that had not expired. Then section 2, subsection 2, paragraph B deals with expired leases. When you read subsection 2, paragraph 2, B clearly states that for expired leases, the law made an extension until the minister had dealt with that property. But when you go to regulation 13 of the repossession regulations, it is to the effect that for purposes of section 2, subsection 2, paragraph B, expired leases had been extended for 2 years until the property had been dealt with by the minister. The question we need to ask ourselves, if the 2 years that are added automatically by operation of law do expire without the minister dealing with the property, does the property cease to be expropriated property or not? Council Gibbs, I don't know whether you are on. Yes. Members, what is the position? Council Latifa, what would be the position if the 2 years that were extended by section 2, subsection 2, paragraph B and regulation 13 expire without the minister dealing with that property? Does the property cease to be expropriated property or not? Or we wait until the minister deals with the property? Anyone with the position of the law? Yes.
Council.
Yes.
I think my view is that
Council, do you have the law with you?
Sorry?
Do you have the law with you?
No, I don't have it here.
That's why you're saying, Council, I think. Read the provision of the law and give its literal understanding. We are using rules of statutory interpretation. Okay?
Okay.
But yes, your opinion is welcome. Kindly proceed.
Yes, I'm of the view that because section 2, subsection 2A deals with before 1983, the coming into force of the Expropriated Properties Act. Then section
Council, I beg your pardon?
I'm saying that section 2, subsection 2A deals with the period before the coming into force of the 1982 Expropriated Properties Act.
Yes.
Now, subsection 2, paragraph B deals with the period after coming into force of the Expropriated Properties Act. So, but then there is also another section, I think, which is it section 4, which provides that not until the minister has dealt with.
Council, we're going to get to section 4 for repossession. Okay, let's first deal with those sections. Only section 2, because if you understand the interpretation of section 2, you have understood the entire workshop.
Okay.
Go on.
Yes. Based on section 2, subsection 2B, I believe it remains expropriated property until the minister deals with it in any way.
Okay.
That is my position as well.
So that means the extension of 2 years, even if the 2 years expire, but without the minister dealing with that property, the property still remains expropriated property. Do you opine with my position? Yes.
Hello?
Yes.
I would wish to state that we really want to understand this point. And what is confusing is the name to do with the land. What is trying to do with that section?
Council, you're not clear.
I am trying to say.
Yes.
Hello?
Yes,
my
Council.
question, as much as you want to understand the point that you're making, let's first get to what the statement means by the minister dealing with the property. What is contained?
That Council, we shall go to the means, ways through which the minister can deal with the property. That's where we are going now. So this implies that when you are reading the workshop or whatever assignment that is before you relating to expropriated property, the first thing you look at the year when the transaction took place. Once you see a transaction between 1973 and 1983, all the transactions between that year are null and void by virtue of section 2. Okay. So put that into consideration. Any question up to that point? So that means all properties were revested back in custodian board, even those that were sold, even those that were leased out, all those that were dealt with in a manner which is not prescribed under the law, they were revested back in the government. So that means by virtue of section 2 and all its contents therein, all such properties were still under the management of custodian board. Are we together?
Yes, Council, we move on. We are together.
Okay. So we've seen who does the management. Okay. Then this property has been expropriated. Now it is under the management of custodian board. So now the question is, how do we deal with expropriated property? Yes, Council Ambrose, your hand is up.
Thank you, Senior Counsel Rashid.
You're welcome.
I have a question. Suppose a transaction was entered into after 1983.
Yes.
But by that time, the minister had not dealt with that property. What happens?
You see the meaning of that section? No any other person should deal with that property apart from the minister. So if you deal with that property when you are not the minister responsible, that transaction is null and void. You don't have, when you look at, is it section 3 of the Expropriated Properties Act, it only gives the minister powers to transfer. Not any other person has the powers. Okay. So now we've seen who does the management and we've resolved what property is under the management of the custodian board. So now our third question is, how do we deal with expropriated property? How do we deal with expropriated property? So the minister deals with expropriated property in different ways as they are well established under the Expropriated Properties Act. Okay. When you look at the very first mode that is supposed to be considered before any other mode is what we call repossession. Repossession. So the question is, one, who can apply for repossession? Section 4 of the Departed Agents, Section 4 of the Expropriated Properties Act is very clear. A former owner of any property or business can apply for repossession. So the question is, who is a former owner? Who is a former owner? Section 1 defines a former owner to mean a person who was a registered proprietor of any property or business in Uganda, and he or she left Uganda during the military regime, and includes his or her legal heir. So sometimes they can give you facts where someone applied for repossession when he or she is in possession of registered powers of attorney. The question is, when you read the meaning of a former owner, do they use legal representatives or legal heir? If the law says legal heir, we take its literal meaning in the literal sense. They require a legal heir, not a legal representative. Okay? Then our next question is, when do we apply for repossession? When do we apply for? Council Vanessa, when do we apply for repossession? When do we apply for repossession?
Council, I'm not sure.
Council Gibbs. When do we apply for repossession? When you look at section 4 of the Expropriated Properties Act, it says that repossession should be applied for within 90 days from the commencement of that act. So you first look at the commencement date of the Expropriated Properties Act. Okay. Then after looking at the 90 days, those days were challenged. And when you look at General Notice number 88, it made an extension of time. To what time? Council Namwanje Rehma. Yes. Yes. The general notice made an extension of time within which to apply. Who came across the general notice?
Councillor Rashid,
Yes.
I don't know whether this is what you want, which provides that take note that the minister responsible for finance shall continue to receive and handle both categories of application up to 30th day of October 1993.
Okay.
After
so,
the 30th day.
What does that mean? If our act was made in 1983 and it said 90 days, so that implies that an extension of time was made by the general notice up to 1993. Those are 10 years from the commencement of the act. But now, the question is, if I just come up right now, can I make an application for extension or I cannot? Yes? Council Michael, yes, you've unmuted your microphone. Kindly shine. Can I make an application now or I cannot?
Can cancel.
You can
Yes.
make an application as per the case of
Yes, Council, we are losing you.
So I think you can make that application since the minister has not dealt with the land.
Council, the law is clear. Council was giving us an authority that challenges that position. Her submission is highly appreciated. Council, kindly vehemently submit or type the case in the chat room for easy consumption. Thank you.
Excuse me, Councillor.
Yes.
Councillor,
Yes, yes.
I think the
Council,
position is in the case of Mabale.
Council,
Council,
read
it's
the
in the
law.
case of Mabale versus. Yes,
The
where
reason why
court
I'm
stated that as long as
okay.
Council
Okay.
in
You can make
in
an
that
application anytime refer to the case of Mawale growers. Look at it, extract the principle only. Okay. So we've seen who can apply and when. Then ask yourself, we presume that you are okay. So we want to see, once you file your application to repossess, what happens? In circumstances where the government is interested in your property, where the government is interested in your property, once you make the application, the minister shall communicate to you the intentions of the government so that you enter into negotiations to make a joint venture entity where the government has shares and the former owner. That is the position. Then, in matters where the government has no interest, the minister may proceed and issue with what we call a certificate of repossession. What is the effect of the certificate of repossession? The certificate of repossession merely authorizes you to repossess on condition that you physically return in Uganda within a period of 120 years. So this implies that the condition for you to fully repossess your property is that you return, if you are not in Uganda, you return to Uganda within 120 days. Okay. So when you look at such circumstances, your failure to return to Uganda within that stipulated time will affect your repossession. So that means you will not be able to repossess that property. Okay? So this certificate of repossession is not giving you full ownership over that property, but the certificate of repossession gives you the power to make an application to the registrar of lands to transfer the property into your names. So this repossession certificate merely acts as a transfer form, but not proof of ownership. So where it has been issued, you are mandated to proceed and make the application to transfer the properties. Okay. So now, if it is not repossession, what other ways can the minister deal with the property? If it is not repossession, what other ways can the minister deal with the property? Yes, Council Birungi, your hand is up.
Selling it or negotiating a joint venture with the owner. There are 3 ways.
Council, negotiating a joint venture is under repossession.
Oh, then selling it.
So now the question is, what factors will lead to the minister selling that property? Okay. When you look at section 9, failure to repossess. So where the following factors exist: 1, where the application for repossession is not a success; 2, where the application for repossession has been issued and the former owner does not return to Uganda within the period of 120 days. Then 3, where the negotiations to conduct a joint venture entity fails, the minister may make an order that the government retains the property. That's 1. That means the property will stay in custodian board. 2, to sell or to deal with the property in any other way. So that means the property should first be not repossessed or not claimed for by a former owner. And they have given you the circumstances under which they will not reclaim property. So where those different factors exist, then the property will be available for sale. So now the question is, what is the procedure of selling? Okay. Yes, Councillor Judith, what's the procedure of selling where the minister opts to sell the property? Yes, what's the procedure of a sale? Wait, yes, Councillor Ambrose.
I think the procedure is provided under Regulation 11 of the Expropriated Properties Repossession and Disposal Regulations.
Yes,
And if I may read verbatim, sub-regulation 1 is to the effect that where the minister makes an order that any property or business be sold, then A, the property or business shall be valued by the valuers as the minister may appoint.
So one,
Subject,
the first step is valuation.
Yes.
Uh-huh.
Then B, They are saying that the property or business shall be sold by competitive tender.
So now, if it is to be sold in such circumstances, competitive tender, how do you get to that? You have to advertise that property, because competitiveness is achieved by advertisement and you welcome bidders. Okay. Then cancel.
Then C, they are saying that the board of valuers shall determine the reserve price for the property or business.
Yes.
Sub-regulation 2 is saying that the committee shall be responsible for advising the minister on the merits of tender bids made for the purposes of sub-regulation 1B.
Okay. So that means after the advert, okay.
In sub-regulation 3, that the committee shall receive and consider the bids, the tender bids.
Okay. So you see, we advertise, we welcome bids, we consider them, we open them, we consider them like that. Okay. And then the committee responsible for that process is known as the divestiture committee.
Yes.
Okay. So now, after that, then they'll proceed and sell, and then you start paying your rent, whatever the case may be.
Councillor Rashid, there is sub-regulation 4, which may also be important.
Okay.
They are saying that the minister shall issue a certificate under his or her own in the form set out in the second schedule of this regulation to a person or body who purchases the property.
Okay. Now, after the entire purchase, you've fulfilled the requirements, you've made the necessary payments, then you will be issued with what we call a certificate of purchase. A certificate of purchase as proof. So then the same issue we dealt with under the certificate of repossession is the same issue here in. A certificate of purchase also just acts the same way as the other certificate. It just gives you the power to make an application for transfer. Okay. Then after, if it is not a sale, which other way will the minister deal with the property? Has the law stipulated any other way? The answer is no. Because the act says or any other, so we don't know. So that means the minister has been given discretionary powers to utilize any other mode of dealing with the property. Okay. Are we together? So
Yes,
now,
senior.
ask yourself, what are the rights of the different parties in such transactions? We have a purchaser, okay? We have a repossessor, stroke a former owner, and then we have sitting tenants. What are their rights? What are their rights? So remember, when you look at section 59 of the RTA, says that a certificate of title is exclusive possession of ownership. So after a transfer has been effected, now you are a registered proprietor because you have a title. So as a result of that, you, as the registered proprietor, you have a right to take possession, actual possession now. You have to enter. So that means if the building is occupied, you have a right of vacant possession. Okay, so you can sue for recovery of land. That's your right. Okay, then what are the rights of the sitting tenants? You have repossessed your property, but you have tenants therein. What are the rights they enjoy? They enjoy basically one right, a right to be compensated for, a right to be compensated for the developments and the renovations they are under. Council, which regulation and section provides for compensation of sitting tenants?
Section 12, subsection 2.
Yes.
The section is to the effect that subsection 1, the government shall pay compensation to any former owner not being a citizen of Uganda whose property or business is affected by section 9.
Okay.
Then subsection 2, where the property or business is returned to a former owner or transferred to a joint venture company or retained by government in accordance with this act, the former owner or the company or the government, as the case may be, shall be liable to pay for the value of any improvements in the property or business to the person or body that effected the improvement.
Okay. So now you look at the facts and ascertain whether there are improvements or developments, whatever the case may be, and then advise that this person should be just compensated for. Simple as that. We've battled the workshop. That's workshop 1 briefly. Any question?
Yes, Senior Councillor Shid.
Yes.
If you see section 10, it is the one that provides for present tenants. Isn't this one different from a person who maybe got a lease?
So we are going to explain the facts.
Okay, sir.
Now, to me, when you're dealing with this workshop 1 has 2 parts. It has part A and part B. Looking at the facts of part A, okay? Looking at the facts of part A, this gentleman acquired a lease, and the 2 gentlemen acquired a lease. Someone to take us to the facts of part A. I need what we call salient facts, the salient features. And probably this would be the best to me, these are the issues I would raise. First, ask yourself, how many transactions are in workshop 1? We have the transaction of the Indians when they acquired the lease first, okay? The lease was a conditional lease of 2 years, which could be renewed for 49 years on condition that they develop that place within 2 years. The question is, did the 2 years expire? Because they acquired their lease in 1971. The 2 years were expiring in 1970, because if it's 1971, 1972, it depends the month, because I'm not having the facts here with me. I can't tell the exact set of facts. Okay.
Councillor Rashid, they had obtained it on 5th November 1971.
So that means in November 1972, it's 1 year. Okay. Then November 1963, 1973, they are 2 years. So unfortunately, these guys left Uganda in 1972, October. Okay. So that means their lease was still running. It didn't expire. So that means for them, they fall under section 2, subsection 1. They had an interest that was expropriated. Okay, because at the time of their leaving, they didn't declare their property. However, through other means, the government expropriated the property and it was under management of custodian board. So that means no any other entity had the power to deal with that property unless it is custodian board under the minister. So now you ask yourself, was there any other transaction after the property was expropriated, and by who? Is there any other transaction? Do you have someone who acquired that land?
Yes.
Who is that?
Mr. Wambede Pone, who obtained the lease in 1990.
When?
In 1990 by Mbare Municipal.
So
District
from
Board.
Mbare, so that means he acquired that loan from Mbare District Land Board, you know so? The question is, who was the rightful owner of that land? Was it Mbare District Land Board or Custodian Board? Yes?
I think it was the Custodian Board.
Okay, because I don't think we have the law. We have the law. We've been reading the law.
Okay, Council.
We've been reading the law together. Okay, so the rightful person to deal with that property was custodian board. By the fact that this land was expropriated, the district land board ceased to have moral authority to deal with that property. So whoever acquired the lease from the district land board didn't acquire good title. Reason: the district land board had no mandate. Okay. Are we together? So that, what does that mean? So we have to raise another issue. Okay. What is the legality of the transaction between Mbale District Land Board and Mr. Wambede? If not, you say what is the legality of the transaction between Mr. Wambede and Mbale District Land Board? Or you say whether Mr. Wambede's interest is protected under the law. Others may say whether the commissioner had the right to cancel the title. So we can solve, okay, in the same ways, okay? So that is part A. Some things are simple. You see? Then part B. Yes. Then part B of the facts. How are they set? Brief facts. Okay. Brief facts. Yes.
The facts shortly are that there are two Indians who had obtained the lease for a period of 99 years.
Now, the simple thing with part B deals with sitting tenants. Okay. How do we deal with them upon repossession? Are we supposed to compensate them? Or a mere tenant, is he supposed to be given first priority when they're disposing of the property or not? Simple as that. That's what they're testing. Okay. Because this guy was a sitting tenant who defaulted. You know, types of tenants. A tenant at surface. Okay. That guy was a tenant at surface because he did not pay rent. He's already a defaulter. So the law doesn't sanction an illegality. So he's illegal occupying the property. So what time does he need to vacate? Okay. Simple as that. Then a simple overview on what is required of us in workshop 2. First and foremost, in workshop 2, first accept the fact that land belongs to the citizens of Uganda in the first place. Then 2, appreciate the fact that the government of Uganda holds in trust of Ugandans different pieces of land as they are mentioned under Article 237. Then after that, ask yourself, what are the different types of lands that the government of Uganda is holding in trust of Ugandans? 1, we have forest reserves. Not all forests are protected. We first gazette, okay, and reserve. So you should first understand what is a forest. We have types of forests, okay? Natural forest and man-made. So regardless of the fact that it's a man-made forest, you can't just wake up and deal with it, because here the main emphasis is protection of the environment. We are analyzing laws that environmentalists deal with. So ask yourself, if not forests, forest reserves, okay, what other piece of land? We have what we call river banks, and then you have lake shores, we have swamps. All those are what we call protected lands. So because the government is holding in trust You cannot just wake up one day. Yes, we know this land is yours as a Ugandan. Okay? As a Ugandan. But you cannot wake up and utilize it just like that. So ask yourself, what is the process of utilizing protected land? You got what we call acquisition of license. These licenses, we have what we call restricted licenses. They can't issue with an open license. Look at the procedure of licensing you. Then under that procedure, we have other laws we need to put into consideration. Okay? Because the essence of this, we have to protect and preserve the environment. Because we survive, because the environment survives. So we have to coexist. So as a result of that, we have what we call the National Physical Planning Act. Not all areas are gazetted for residential. So you first look at the National Physical Planning Act. What does it require? Okay? What are you going to do? If you're going to construction, we have the law known as the Construction Act. What does it require? All the material to use should be approved. You should submit a plan from the approved architecture. Then after that, before you start constructing, you have to you go to the NEMA Act. It talks about the impact assessment. First, make the assessment. How is your project going to affect the environment? Is it so grave? Is it minor? Is it minimal? Regulate the chances of such risks happening in that impact assessment. So once you submit all of those required documents, then the ministry will sit and they analyze whether your application is granted. If it is granted, then you proceed and carry out what you intend to. But emphasis should be made on what and where. If you're going to deal with the forest, we have to look at the NF Act and the NEMA Act. If you're going to deal with okay, are you going to deal with the riverbanks? Look at the riverbanks regulations. Okay, what type of business is allowed in the riverbanks? Not all businesses are allowed. Are you going to use lake shores? Look at the lake shore, okay? Riverbanks and lake shores regulations. Things are very clear, okay? So write your application and then submit. If it is considered, you'll be given the license and we start operating. Very simple like that. So we shall have our detailed class on workshop 2, that is tomorrow. The reason why I had to make so let's take time, okay? And read. Those things are very simple. Okay. So any question, comrades?
Yes, Councillor Rashid.
Yes.
Now, in part 2, is this guy the tenant? Does he only have one remedy of compensation? Because they are telling us now to identify the rights and remedies of different parties.
Yes.
So they want the rights and remedies of each party.
Basically, what they want, sometimes what is a right to this side, okay, is a remedy the other side. We use them interchangeably. Okay. Are we together?
We are together.
Yes. So that's our, these things are quite simple. And I believe we can really make wonders. Not so? So should we call this off?
I think senior counsel.
Okay,
Thank you.
so you're welcome. Thank you, comrades, for accepting, and we share this together. I know it has been a fix, but we shall keep pushing until the end. So let me wish you the best. May the good Lord bless you. Let's meet tomorrow, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.